Welcome. My name is Cynthia Pyle, and I am a Labor Relations Specialist with Accountability and Workforce Relations here at the U.S. Office of Personnel Management. It gives me great pleasure to welcome you here today for this training entitled the Federal Service Impasses Panel. Our office presents trainings in support of our ongoing effort to bring relevant and reliable developmental opportunities to federal sector employee and labor relations practitioners. The President's Management Agenda, PMA, recognizes that federal employees underpin nearly all of the operations of the government, ensuring the smooth functioning of our democracy. The PMA is a comprehensive strategy to make government more efficient, effective, and accountable through 3 pillars: 1, mission; 2, service; and 3, stewardship. Today's presentation supports the PMA by aligning staff skills with the government's evolving needs to deliver mission outcomes. Our speaker will provide an overview of the Federal Service Impasses Panel, how to resolve negotiation impasses before the panel, and jurisdictional considerations. Fiscal year 2019 impasse decisions will also be discussed during this session. The case law is updated as of April 1st, 2019. And please note that your viewing instructions also include a SurveyMonkey hyperlink to an online evaluation form. Simply click on the link, follow the instructions, and your valuable instant feedback will be sent to us. And we're pleased to have as today's speaker Amanda Gill from OPM's Accountability and Workforce Relations Policy Office. Amanda is currently serving as a labor relations advisor. She has over 25 years of federal service, including significant experience in employee relations, in addition to her labor relations expertise in the interpretation of labor agreements. Please join me in welcoming Ms. Amanda Gill.
Thank you, Cynthia, and welcome everyone. Today we are actually going to spend about the next hour and 15 minutes talking about the Federal Service Impasse Panel and what that means to us as labor relations practitioners in the federal government. So first thing we are going to talk about is unionized environment and collective bargaining in the federal sector. Title VII of the Civil Service Reform Act of 1978 governs federal employer and employee labor relations. The Civil Service Reform Act specifically declares labor organizations and collective bargaining in the civil service to be in the public interest. Accordingly, the Act provides federal employees with legal rights similar to those that are provided by Section 7 of the rights under the National Labor Relations Act that governs private sector employees. So the Act states that employees of the federal government have the right to form, join, or assist any labor organization, or to refrain from any such activity freely and without fear of reprisal. And each employee shall be protected in the exercise of those rights. The Civil Service Reform Act created the Federal Labor Relations Authority to establish policies and guidance for the administration of the labor management relations provisions of the Act. The FLRA determines the composition of employee bargaining units, supervises or conducts union representation elections, conducts hearings to resolve complaints of unfair labor practices, and resolves issues involving the duty to bargain in good faith and any exceptions or appeals to arbitral awards. The unfair labor practice provisions of Title VII are familiar to those of the NLRA. However, there are 5 major differences. The first is that federal employees are denied by statute the right to strike. The second is the right of federal employees to picket, but it is limited to informational picketing only. The third of the differences is the scope of mandatory collective bargaining for federal employees is limited to personnel employment practices only. Basic working conditions such as wages, hours of work, and employee benefits are instead subject to statutory provisions. The fourth is union and agency contract provisions mandating compulsory union support are prohibited in the federal civil service. Unions are required to represent the bargaining units regardless of membership status of individual BU employees. And the last difference is recognition of labor organizations as exclusive employee representatives occurs only by a majority vote of employees through a secret ballot election. But at the end of the day, what this really means is with the implementation of the act, it is deemed, Congress has determined that labor organizations and collective bargaining in the civil service are in the public interest and are in the interest of employees. Okay, just a little bit of history on the no striking provision in the federal government. If you take a step back, that is something that's really unique, but the no strike requirement or obligation or duty, as it were, for all federal employees is minimized or is at least mitigated by the right to resolve disputes through these impasse procedures, and thus we have the Federal Service Impasse Panel. But just a little tidbit of history. In August 3rd of 1981, there was a strike, federal government strike. Actually, the Professional Air Traffic Controllers Organization, known as PATCO, was a U.S. trade union that operated from 1968 until its decertification in 1981, following a strike that was declared illegal and broken by the Reagan administration. According to the labor historian Joseph McCartin, the 1981 strike and defeat of PATCO was one of the most important events in the late 20th century U.S. labor history. So just a little background, on August 3rd, 1981, union declared a strike seeking better working conditions, better pay, a 32-hour work week, general conditions of employment. And on that same day, during a press conference regarding that strike, President Reagan stated, "They are in violation of the law, and if they do not report for work within 48 hours, they will have forfeited their jobs and will be terminated." So at that point, President Reagan declared the strike to be a peril to national safety and ordered the striking members to return to work. Of nearly 13,000 controllers, only 1,300 returned to work. So on August 5th, after the refusal of the employees to return to work, President Reagan fired over 11,000 employees. So, and at that point, PATCO was decertified by the Federal Labor Relations Authority on October 22nd, 1981. So just a little interesting tidbit about no strike. So we do not strike in the federal government and labor relations. So moving to the topic at hand, the Federal Service Labor Management Relations Statute is what gives rise or gives the authority to the panel. The Federal Service Impasse Panel is an entity within the Federal Labor Relations Authority, the function of which is to provide assistance in resolving negotiation impasse between agencies and their exclusive representatives. The impasses are a result of activity under the Federal Service Labor Management Relations Statute and the Federal Employees Flexible and Compressed Work Schedules Act. And we will actually talk about that in a little bit of detail coming up in a future slide, because the majority of the work that we are going to focus on really arises out of issues that come up under the statute. And when I say the statute, I do refer to the Federal Service Labor Management Relations Statute. So in processing a case in front of the impasse panel, really you are dealing with an issue of negotiability impasse, an issue where the parties cannot reach agreement. On the slide, if you refer to the slide, it talks about what the FLRA, the other areas that the FLRA has oversight over as well. And the first four bullets, when we talk about unfair labor practices, representation, arbitration, negotiability. Those are all matters that actually are reserved for the FLRA. The impasse panel is the last bullet on your slide that talks about impasses addressed during negotiations. So, 7119A, before all else, the help starts with the FMCS. This is a roadmap, but this is what we are going to actually discuss today. It really talks about the process. It's a visual representation of the process of the panel. Most impasse mediations, if the parties declared an impasse, they would actually file with the authority for assistance. And at that point, parties can get mediation assistance during negotiations. So this isn't a process that's utilized just at the tail end of collective bargaining or only when you've determined that you can go no further. The impasse panel does provide resources for parties to actually have mediation assistance while they are in negotiations, and which actually could be very beneficial to actually reach conclusion on negotiations rather than having to go to impasse procedures. Most impasse mediations are handled by FMCS mediators who conduct negotiation mediations without cost to either party. The panel, or I might refer to them as FSIP during the course of this presentation, requires proof of mediation, which usually includes an FMCS case number on the request for FSIP assistance. The request for assistance for negotiation impasse requires information on the number, length and dates of negotiations, mediation sessions held, name and address of the mediator, and the case number. 7119A, the FMCS, it starts with direct negotiations attempt at voluntary settlement. Under the Labor Management Relations Act of 1947, FMCS provides free services in contract negotiation disputes between employers and unionized employees. Collective bargaining mediation is a voluntary process in which a third-party neutral assists labor and management in reaching an agreement on a negotiated agreement. However, I want to reemphasize this is a voluntary process and generally a process that both parties are in agreement with. There are often times when parties might want to bring in a mediator, or one party wants to bring in a mediator, and the other party does not necessarily want to do that. So it has to be jointly agreed if you want a mediator during the process of negotiations. FMCS mediators communicate both with labor and management parties on their collective bargaining agreement prior to the start of negotiations. They like to determine, the interest of each party. At the request of both parties, they can provide assistance during negotiation sessions. They would use their own knowledge of the industry, similarly negotiated provisions, their experiences in other federal agencies, and the issues that the impasse panel or FMCS has had to deal with to guide negotiators past potential barriers or settlement. Mediators may offer procedural or substantive suggestions and recommendations throughout the process. However, a mediator does not have authority to impose a settlement or to determine contract terms. The FMCS receives appropriated funding to provide its labor management services. There is no charge to the parties for collective bargaining mediation. So who is on the panel? The structure of the panel is, as you see on the slide, that is the current structure. We have 7 neutrals appointed by the president, and then the staff that supports the activities or the logistics of the panel members. I would encourage, if you are actually going to be presenting or working with the impasse panel, I would encourage you to take a look at the backgrounds of the panel members. There's a variety of background, and it might actually inform you as to how to deal with certain or how to present certain issues in front of panel members. So what does the panel do? Panel has jurisdiction under 5 U.S.C., and by U.S.C. we are referring to the United States Code, 7119, negotiations impasse. Right? As we discussed on slide 2, I believe this is the priority, and this is the primary responsibility of the impasse panel, and that is to help or assist parties in reaching resolution through mediation or in assisting in direct negotiations. So the jurisdiction of the panel governs approval of binding arbitration or other voluntary arrangements. Panel asserts jurisdiction only, 1, if voluntary efforts by both parties have been exhausted, and neither party has raised a bona fide jurisdictional issue. Now, when I say jurisdictional issue, what that means is panel does not resolve bargaining obligation disputes, negotiability disputes, questions concerning representation, or grievances. There are only limited areas in which the panel actually might address negotiability matters, but we'll actually talk about that further on in the presentation. So before asserting jurisdiction, though, the panel is going to attempt to see if the parties have made every effort to resolve their issues. And the slide that you see up, these are probably the top 10 options and strategies in breaking impasse or working through barriers when you are in negotiations. I think they pretty much speak for themselves, but it really comes down to research, knowing what the agency is looking to gain and where it could concede. And that really is an important point. If you look at the last bullet on the screen, sometimes conceding an issue is an appropriate response to an impasse. I know that's not something I, as a labor relations professional, really like to hear as much, and there might be some of you that don't feel that way either. But really, it's about the bigger picture, right? So it's look at alternatives if you need to concede an issue, right? If there is something that's more important, right, for the agency and something's more important for labor, then you can generally work out some type of resolution. So again, I really can't emphasize enough that before you go to or declare impasse, I think the parties should do everything in their power to attempt to resolve their impasse before going to a third party. All right, but when that doesn't happen, when you have tried and you are at impasse, then you have to go to the panel. And when cases go to the panel after a party files, or actually if the parties jointly file, because that can be done too, the panel staff will conduct a preliminary investigation. Right? They will have contact with the parties. They will discuss the steps that you have taken. They'll discuss what your outcome or what the goals are for outcome. And then they will also look at those areas that you cannot make any further movement or that you declare that you are at impasse for. Following the investigation, the panel may determine to assert jurisdiction over the request. If the panel does assert jurisdiction, then it has the authority to recommend and or direct the use of various dispute resolution procedures. If the parties are still unable to reach a voluntary settlement after the use of those procedures, the panel may take whatever actions it deems necessary. And yes, I did say whatever actions it deems necessary to resolve the dispute, including the imposition of contract terms through a final action. The parties may not appeal the merits of the panel's decision to any court. So, I'm going to take a second here just to step back and say, when I talked about the last slide, it is beneficial for both parties to attempt to resolve their own disputes or their impasse, because then you would have at least crafted a resolution that's crafted by the parties. When you go to a third party, I personally would prefer to resolve something myself than have a third-party directed resolution. Now, that is just my personal opinion, because there are times when you really have no choice but to go to a third party because of the nature of the impasse. But having said that, we will move forward. So once the panel asserts jurisdiction, then what happens? While considering jurisdictional issues, the panel will assert jurisdiction only if, again, voluntary efforts have been exhausted, neither party has raised a bona fide duty to bargain jurisdictional issue. So it's one of those items that I mentioned before. The panel will not be looking at duty to bargain or negotiability issues. Those would be reserved for the Federal Labor Relations Authority. And this comes from longstanding case history with the panel. The Carswell case that is actually referenced on this slide When considering jurisdictional issues concerning negotiability disputes, that is the duty to bargain, the panel follows guidance provided by FLRA in Carswell, as well as actually another case that we'll speak to on the next slide, and that's Department of the Interior, Bureau of Reclamation, Lower Colorado Region, Yuma, Arizona. We'll refer to it as Yuma, just for succinctness. So in Carswell, the authority stated that the panel and interest arbitrators may apply existing FLRA case law to resolve duty to bargain issues, which are negotiability issues, which the authority has previously found a substantially identical negotiability position. A previously substantially identical position to be negotiable. So, in simplification, what that matters is that the FSIP, if there is a negotiability issue in front of the impasse panel, and that particular issue actually has been addressed by the authority in a different case, but in its case law, then the impasse panel can apply the authority's analysis in that limited circumstance. So in Yuma, the authority clarified that guidance even more, or further, I should say, and stated that undecided duty to bargain issues will be resolved by the authority. So we have the first case in Carswell that says that the authority or the panel actually has some authority to take existing case law to support any type of decision that they issue. In Yuma, however, they went further and say that Carswell does not require an employer's negotiability argument in an impasse proceeding to be identical to arguments previously addressed by the authority. So nothing requires the panel to defer to the FLRA simply because an employer raises a novel, sometimes frivolous, negotiability argument so as to impede the impasse resolution. So really what that says is that they're not going to sort of leave open the door for nonsensical, unrelated, maybe frivolous arguments just to sort of delay the process. And so the impasse panel does have the authority to make those types of judgments or assessments. However, what they did say is that if there is new or novel argument that has not been addressed in case law, then that is a reserved right for the authority. So the matter in Carswell came before the authority on exceptions to an arbitration award filed by the union under 7122A, Section 7122A of the statute, and Part 2425 of the FLRA's rules and regs. The award consisted of a number of bench decisions issued by an arbitrator on proposed contract language, articles submitted to him by parties in an interest arbitration proceeding. The parties reached impasse in bargaining on new CBA and requested the panel to pursue, so we'll take a step back in background. The parties have reached an impasse on bargaining on a new CBA and requested that the panel approve a procedure for binding arbitration to resolve the impasse. The panel approved the parties' request. After 1 day of mediation, the parties agreed the mediation was not effective and decided to submit the disputed proposals to binding arbitration. So the case presented an issue to the authority as to the authority of the arbitrator to consider duty to bargain issues raised by the union. The authority concluded that interest arbitrators and the panel have the same authority under the statute to consider duty to bargain issues which arise in negotiation impasse, and that interest arbitrators and the panel may apply existing FLRA case law in resolving such impasses. In this case, the authority found that one arbitrator award pertaining to the number and location of union stewards in the workplace was deficient because the arbitrator did not have the authority to resolve that impasse as to that matter, and the FLRA ordered the parties to resume negotiations on that issue. So, the FLRA found that the union's exceptions concerning other portions of the award provided no basis of finding an award deficient and upheld the arbitrator's decision. So in this particular case in Carswell, they actually remanded to the parties to negotiate. Questions that were considered by the panel in determining whether the arbitrator applied the existing authority case law in resolving the impasse. Was the proposal raising a negotiability or duty to bargain issue? That, of course, was the primary importance. Were the parties' contentions before the arbitrator similar to ones addressed by the authority in previous cases? And did the arbitrator cite and discuss applicable authority case law and other relevant precedent? The FLRA will resolve exceptions on the merits by determining whether the arbitrator correctly applied existing authority precedent. So again, all that this says, and the last 3 slides have said, is that there is limited jurisdiction for the panel and for interest arbitrators in addressing negotiability or duty to bargain issues, whether they're at impasse or in the arbitration process. All right, there's actually another significant case, and that was the SSA case that also talked about bargaining obligation disputes. So in Social Security Administration, the case that is before you on this slide, it came before the authority on exceptions to an award filed by agency and by the union under 7122A. So as we mentioned in the previous slide, 7122A triggers a different process. And Part 2425 of the FLRA's Rules and Regs. The parties reached impasse in bargaining on a supplemental agreement. This was a supplemental, not actually a term negotiation, and were directed by the impasse panel to submit their dispute to mediation arbitration. The arbitrator was given the authority by the panel to issue a final decision on outstanding issues. Both parties filed exceptions to various portions of the award. In this case, one portion of an arbitrator's award was set aside, dealing with accommodations for pregnant VDT operators because there was no clear FLRA precedent on the issue, and since the agency asserted its claim of non-negotiability, the arbitrator did not have the authority to resolve the impasse on this particular issue, and the award was deficient for that particular reason. And the 2 remaining exceptions, 2 remaining agency exceptions, and 5 other union exceptions were all denied. So it was that one limited aspect that was determined to be outside of the scope of the panel or the arbitrator. So that actually takes us to another SSA case, and that was a bargaining obligation dispute. This is actually on your slide. It is 47 FLRA 1004, and this was a 1993 case. And in this particular matter, the authority held that an employer is not obligated to bargain over union proposals midterm when the subject is covered by an existing collective bargaining agreement. The framework applies to cases in which an employer asserts that it has no duty to bargain based on the terms of a negotiated agreement, whether the context of the bargaining is union initiated or due to an employer decision to change conditions of employment midterm. So in this particular case, the authority specified that the framework is intended to apply only to cases in which an agency asserts that it has no obligation to bargain based on the terms of a negotiated agreement. The panel has reserved its discretion to decline or assert jurisdiction where a bargaining obligation dispute is alleged, depending on the circumstances of the case, with the only restriction that the panel acknowledges is that it will not issue a final decision or a final action, I should say, in favor of a proposal where a bona fide bargaining obligation dispute is raised. So again, that just goes back to what we've said in the last few slides, is that if there is a bargaining obligation or a negotiability dispute, generally the panel is not going to assert jurisdiction. So in this particular case, the union filed a ULP before the authority and then filed exceptions to the decision by the FLRA administrative law judge. The judge found that the agency did not violate the statute as alleged and recommended that complaint be dismissed. The complaint alleges that the agency refused to negotiate with the union regarding incentive awards. And in this particular matter, so it was incentive awards for bargaining unit employees in violations of 7116A1. So in this case, the authority found the agency was not obligated to bargain with the union over any of the proposals submitted and did not violate the statute by refusing to do so. So the authority found that the proposals involving notification to the union about award money, about total amount designated for, et cetera, was covered by the parties' master labor agreements. So therefore, there was no duty to bargain in this particular instance. Compressed work schedules. Not really sure that we actually touched on this in an earlier slide, or actually I might have referenced that the authority or the impasse panel has the authority and oversight to look or act on negotiation impasses, as well as certain cases that arise under the Compressed Work Schedules Act. And that is what we're actually referencing in this particular slide. So the act was effective in 1982, and it became, well, it's been effective since 1982, originally experimentally, then of course permanently. And what that does require is that it requires agencies to negotiate with unions over the establishment or termination of existing flexible and compressed work schedules for federal employees. Any impasse over the agency's decision does go to the impasse panel. So the authority does lie with the impasse panel adjudicating these types of cases. There's no requirement to go to mediation in this particular situation prior to filing with the impasse panel. The sole issue before the panel is going to be whether the agency's determination that the proposed schedule would cause or has caused adverse impact to the agency, and that's defined by 5 U.S.C. 6131. So if an impasse is reached while bargaining, the parties can come back to the panel via Section 7119, and then mediation is required if they go through the traditional impasse procedures. So basically what that says is if there's a dispute that arises under the Compressed Work Schedules Act, parties can go directly to the impasse panel. If the issue is as described on the slide, right? If there is any adverse impact. However, if you go through traditional negotiations and then you are going to the panel via the traditional route of impasse, then we would go through the traditional route of mediation before getting to the impasse panel. So, what does the panel do? Actually, I think we've been talking about some of this. We're talking about what they oversee or what is under their jurisdiction. What do they do when they assert jurisdiction? Well, there's several activities and following the roadmap, one of which could be that the panel member or designee, right, can identify dispute resolution procedures, one of which is mediation arbitration. MEDARB, as we called it, right, is where there is two distinct, well, actually, it could be handled in more than one type of way. It could be that the panel identifies one neutral or two neutrals to actually engage in this process with the agency. It is really more or less dispute resolution process that the impasse panel utilizes before moving to the other forms of addressing the issue or other forms of resolution that it has under its authority. Starting with the most informal, least restrictive form of ADR, they'll do a mediation. So the neutral will conduct a mediation. If it's successful, parties agree, they settle, they move on. If the mediation's unsuccessful, then the neutral becomes the arbitrator and would actually hold arbitration. The approach is more or less considered to be an informal and cooperative manner of addressing disputes, at least more so than the other processes. The types of MEDARB, as I mentioned, the panel can order one neutral. Neutral will act as a mediator and an arbitrator. So the neutral would actually conduct a mediation session once all matters that could be resolved or resolved if there are any outstanding issues, that same neutral would become the arbitrator and then order or issue a decision ordering resolution of the final outstanding issues. You could actually have a meet arb ordered with two different neutrals. And in this particular situation, it's the same process. One neutral would conduct the mediation. The second neutral would actually be involved in the arbitration process. And once that actually occurs, then the arbitrator would actually provide a binding final decision. This is actually a great method. I've actually had the experience a couple of times in my career because it really does give you the opportunity to have maybe a facilitated discussion with your labor or your agency counterparts, depending on who you are, and helping in at least attempting to resolve the matter informally. I think informal resolution really does the best thing to preserve the relationship between management and labor. So I think meet arb is actually a really, really, it's a positive. It was a positive experience for me, and I think it would be a recommended approach for me as well, because not only does it save time, because you attempt to resolve, but then if you don't, you get a final binding decision as well. So this is something that I think everybody should at least explore once or twice in their career, and it has actually proven to be quite effective. Arbitration. Then, of course, we have traditional arbitration. If we don't do meet arb, the panel could direct arbitration. I don't know that there's much more to say except, it's ordered, and then they conduct an arbitration proceeding and issue you a final agency decision or a final binding decision for each party. All right. So if we don't do meet arb or arbitration, there's always private arbitration. And I think most LR practitioners that I've worked with have all had some level of experience with arbitration. So this could actually be ordered by the impasse panel. They could order the parties to resolve the impasse through private arbitration and close the case. So there would be no further panel action. And typically in these types of situations, parties are directed to share the fees and the expenses of the private neutral. Voluntary arbitration fact-finding are widely used in labor management relations. And if you actually don't know where to go, FMCS, Office of Arbitration, provides services for parties seeking arbitration through its roster of approximately 1,000 arbitrators. FMCS actually oversees the roster to ensure that compliance with policies and procedures, FMCS policies and procedures, and with the Code of Professional Responsibility for arbitrators. The director, actually, you go on their website, it's actually pretty easy to navigate and find the contact information, but the director of arbitration is Arthur Perlstein, who actually has been around for some time, is actually quite familiar with the process, and in my experience, actually very, very helpful to agencies or to new practitioners. So feel free to reach out to Mr. Perlstein if you have any issues regarding arbitration. But if it's not either of those processes, and I'm going to take actually a step back, then we are looking at informal conference by a panel member. So now this is where the panel is heavily involved in making determinations on impasse proceedings. So panel member or senior staff member would meet with the parties to attempt a voluntary resolution. If it hasn't actually come through thus far, voluntary resolution is what we always hope to find. We know it doesn't always happen. That's why we have this process. But an informal conference is going to proceed like a meet arb, except that there is no merits decision. That would be reserved by the individual. So the merits decision is reserved for the full panel. Unlike the meet arb, you have the one neutral that makes a final and binding decision. The panel considers findings and recommendations and issues a written decision involving or resolving the outstanding issues. Written submissions, that is generally the most typical type of order that you're going to get from the panel. And it's used when issues are pretty clear cut. There's no likelihood of a mediated resolution, and there's really no need to develop a record because the parties actually have developed records. And that's usually what happens in this situation for written submissions. The parties have lengthy developed records and can provide them for the panel to review. Current cases have used this technique of written submittals with opportunity for rebuttals quite often, actually, if you go back and look at the last couple of years of panel decisions. The panel can also actually issue an order to show cause. And that's typically used when they require the parties to demonstrate why the fact-finding report recommendations should not be adopted. Rarely used in other contexts. So if you're following the process here is that when you go to the impasse panel, if they have a fact finder, whether it's a neutral or a staffer that engages the parties, finds out the history, the bargaining history, finds out what prior situations, finds out agency goals, at labor goals, and then would make a recommendation as to a solution. However, neither party has to accept that recommendation. And it's typically when a party says, no, we don't necessarily agree with this, that is when you're going to get the panel's going to issue an order to show cause as to why the recommendation should not be accepted. All right. Parties ordered to mediation fact-finding by private neutral selected by the parties. So this is sort of the process that I was talking about, but it's generally used or reserved for situations where you actually have a large number of outstanding issues. The private neutral will engage the parties in mediation again. They'll do the fact-finding. So as I just actually sort of described the process, that's really on this slide. When a party does not agree with a recommendation, and this goes right back to order to show cause as to why. All right, finality of the panel action. What can I say? It's final. That's really probably the best 3 words I can tell you. If you actually, we're looking at INS case, Department of Justice, Immigration, National Naturalization Service. The panel is empowered to direct parties to use interest arbitration under Section 7119B1 of the statute. So where contract language is imposed as a result of an interest arbitration under the section, an agency head retains the right to review the language under Section 7114C. Challenges to such agency head review may be brought under negotiability or ULP procedures of the statute and the authority's rules and regs. So most importantly, the authority will no longer entertain exceptions filed under 7122A to contract provisions imposed as a result of interest arbitration under Section 7119B1. So what does that mean? What that means is if say the parties, we have management and labor, agree to go to arbitration, right? A private arbitration. So this is something that the parties jointly agree to. And an arbitrator issues a decision. That decision is binding. All right. The distinction here is if the panel sends the parties through the fact-finding process, or if the panel dictates arbitration, in those circumstances, the provision is subject to agency head review. So 2 distinct differences as far as what process that you are going to be utilizing. So for anybody out there, just remember this. If you and your counterpart, let's say your party involved in the negotiation, agree to arbitration, then you will agree to be bound by the decision of that arbitrator. of course, assuming that the arbitrator is actually, issued everything that is not, that the decision is not contrary to law. It's not. It's finds itself in the essence of the agreement. All those other matters. Finality of panel decision order arbitration awards. 7119B1. So this was what I was just talking about. And the case that we're referencing here on the slide is DOD, Office of Dependent Schools. So in this particular case, the United States Court of Appeals for the Fourth Circuit rejected the authority's position that agency heads are not empowered to review provisions directed to be included in collective bargaining agreements as a result of interest arbitration awards. The court found that where parties reach an impasse in their negotiations, they may either request the services of the panel to consider the matter under Section 7119B1, or they may agree to binding arbitration under Section 7119B2. The court further found that when assistance is provided under 7119B1, the panel's decision is subject to agency head review under Section 7114C, regardless of whether the decision was issued by the panel itself or by a panel designee. The court also discussed the applicability of Section 7122 of the statute and concluded that a decision of a panel designee does not constitute binding arbitration, which is subject to the filing of exceptions and review under Section 7122. However, review under Section 7122 would be available to either party dissatisfied with an arbitration award issued pursuant to Section 7119B2. So I think it's probably one of the clearest decisions that I've read in a while that talk about which direction or which avenue and what the rights are of the parties. And actually, we're going to move to the next case. In this particular B2 case, it's also a DOD case. So on this particular case, on remand, the authority adopted the court's conclusion that a decision of a panel designee who serves as an interest arbiter is subject to review. So the authority adopted the court's position that a case that is raised under 7119B2 would actually be subject to agency head review, and then as such would be subject to filing exceptions with the authority. Subsequent to the authority's decision on remand, the Fourth Circuit actually issued 3 other decisions holding the same position that the authority, that agency head review, right, may find a provision or might determine that a provision should not be included in a collective bargaining agreement. And those cases was a DODEA, Department of Defense. Actually, it was dependent schools. There was DLA versus the FLRA. Now, mind you, these are all versus the FLRA because the FLRA had held contrary to that position prior to that. And then there's a Patent Trademark Office versus the FLRA. And I want to say all these cases were probably around 1989, 1990. So the U.S. Court of Appeals for the Fifth and the Ninth Circuit have taken the same position as the Fourth Circuit concerning Section 7114C review. And the particular case is referenced actually on this slide. It's the Panama Canal Commission. In this particular case, the court found that where both parties agree to binding interest arbitration under Section 7119B2, the interest arbitration award is reviewable under Section 7122, but is not subject to agency head review. So, the court held that where an impasse is referred to the panel under B1, agency head review. Well, so basically, let's just say it's the exact opposite of what we just said, right? So under 7119 B1, it is not subject to agency head review. All right, and then actually I want to cite another case, and I don't believe that. Oh, it is on here. The court's decision on that. Well, actually, the court's decision in the Panama case was adopted under the International Organization of Masters, Mates, and Pilots. But then there was actually another case, Department of Agriculture case in the Western region. And the Ninth Circuit adopted the view of the other circuit courts that agency heads are empowered to review provisions arising from interest arbitration imposed by the panel. So we have actually a litany of cases that actually uphold, and a lot of the circuits upholding the same, guidance, and the authority has accepted actually that guidance in doing further review or looking at exceptions. So, having said all this, how to be successful before the panel. And none of the next few slides should be a surprise to anyone. I think it's true when you talk about how to be successful in actually being a labor relations or a professional in the federal sector, right? Avoid substantive and procedural mistakes. And I can actually speak to that from experience. Had a few situations where we missed a timeline by a day. Can't do it. Don't miss your timelines. So, practical issues to avoid. E-file. You have the ability to e-file. You still have the ability to submit hard copy requests for assistance to the panel, but they do also have now an e-file system, and it is actually quite easy. It requires the same material that you would utilize to do hard copy filing. Jurisdiction, make sure that all your mediation efforts have been exhausted. Make sure, is there a duty to bargain question? Don't engage in protective filings, and don't forum shop issues. That can be a challenge, especially when the panel and the authority, right, reside. The panel is a part of the authority, so be careful about shopping these with a neutral or with a third party. And be careful to avoid mistakes as far as their role in administrating decisions for AWS, CWS changes. I will say this, the authority and the panel are very committed to the timelines, and they will hold the parties accountable to those timelines and to submit appropriate submissions and all the supporting documentations. So what is the one thing that you can do for yourselves? Research, research, research. If you're doing this job, you know the value of research. There's no substitute. And the recommendation would be start your research before you even start negotiations, because you will, as a practitioner or having experience with labor organizations within your agency, you will know and you will have an idea of the types of issues that will arise during negotiations. You will also know that some of those issues may not be ones that the agency will want to concede on. So the best thing you can do for yourself is make sure that you researched any decisions, authority and panel decisions related to those issues that you might actually have to seek assistance for. Review of decisions and orders. I think this slide is actually very self-explanatory. Be clear. Make sure that you have complete argument. The respective union employer proposal sections are from the prospective party. So if you are looking at a decision of the panel, this slide really does just talk about what the decisions and orders are going to state. They're pretty clear. They're pretty concise. They tend to reiterate the positions of the parties, and then they'll find that they say the conclusions are written actually fairly clearly, and actually will be quoting one or both parties. And as noted, make sure you have strong supporting evidence for your proposal. That is really the key. We're going to actually discuss a few of the cases that the panel has actually, a few decisions the panel has rendered since late last year and into this year. And it is quite clear from the analysis in those decisions that the strong supporting evidence, so not only making the argument, make your argument, but the parties that have the strongest supporting evidence and that actually probably have calculations of cost and impact to the agency are the ones that actually are successful in front of the panel. So if nothing else, put more information in than you think you need to have. But also, refrain from frivolous arguments. Always go with your strongest arguments, your strongest position, and make sure that you put those up front. So, what happens if an agency refuses to adopt a provision imposed by the panel? In this particular case, we're talking about NTU and Department of Homeland Security, Customs and Border Protection. This matter came to the authority as exceptions to an arbitration award under Section 7122 of the statute and the authority regulations. The arbitrator found that the agency did not violate the statute or the parties' collective bargaining agreement by failing to implement a decision and order of the panel. The authority found that the arbitrator award was contrary to law and directed the agency to, 1, cease and desist from failing to implement the panel's decision and to incorporate the panel-imposed provision into the CBA, to post a statutory violation notice, and then provide a letter to the union explaining the agency's compliance methodology. The issue for the panel decision was carrying privately owned wireless communication devices in inspection areas. The panel determined that it had jurisdiction to decide whether the union's proposal was negotiable and decided that the proposal was negotiable because it's substantively identical to a proposal found negotiable in a prior case. So the panel ordered the parties to adopt the union's proposal, which it refused to do so. The arbitrator on remand determined that the provision was excessively interfered with the agency's right to determine the technology of performing work and to determine its internal security practices, and to assign work, and the right to assign work. The arbitrator found the proposal provision to be non-negotiable. And in this particular case, and therefore the agency's failure to implement did not constitute a violation of 7116A of the statute. Union filed an exception to the arbitrator's decision, and the authority stated that the arbitrator actually did not lack jurisdiction because it did not depend on the panel's jurisdiction, but rather from the grievance alleging the agency committed a ULP. In this particular situation, that the authority stated it was unnecessary to determine whether the arbitrator erred in concluding the provision was not an appropriate arrangement because they had made the determination that it did not impact any management right. All right, now we get to 2019 case law, recent case law, and panel decisions. First case that we are going to talk about, National Council of Field Labor Locals and Department of Labor, Office of Workers' Compensation. In this particular case, the collective bargaining agreement at DOL was silent on the method and manner of moving employees. Parties were negotiating a new contract, and there were 4 proposals that were at issue at impasse. One was employees impacted by the change, selection of new workspace, movement of personal belongings, and allowing some employees to not move. In this particular situation, the MOU panel made determinations on the 4 space issues at impasse. So basically the easiest thing to say is they did assert jurisdiction because, as we know, these are all negotiable matters. Neither of the parties actually raised an issue of non-negotiability, and it looks like it was a majority of the management decisions, but with some slight modifications that were implemented. So it actually does talk about these were the only 4 issues that went to the panel because they were negotiable matters. In the particular case, if you look at it yourself, there are actually quite a few proposals in which the panel declined jurisdiction. And submission of written procedures and the statement of positions were related to those in which they actually did assert jurisdiction only. So the next case we have is the Department of Defense and Antilles Consolidated Education System. So union requests panel assistance from mid-year negotiations regarding proposals. So the proposals center around the appraisal cycle in this particular area. And DOD actually has their own internal instruction that identifies two ways that, or two time periods appraisals can run through. So whether the appraisal period should run through X date and Y date, that was one of the issues that was considered by the panel at this point, is the appraisal period year. And the panel ordered a modified solution. Of course, management had identified a certain time frame, which was May 1st through April 30th. The union wanted to maintain status quo, which I believe was toward the end, closely aligned with the end of the school year. And in this situation, the panel actually modified the provision, and they identified that the appraisal period would commence at the start of each school year and run through the end of the school year in June. So in this case, it was a modification, but it was more or less the union proposal that was modified, and not the management official. And then there was also the other issue was whether employees should be compensated for extra time they spend performing work as a result of the assignment of training on new performance appraisal system. And the panel found that the agency's proposal was the best alternative in this particular situation. The union didn't provide compelling evidence that training on the new system would impact the employee's ability to accomplish their work assignments in their regular day. So one of the things I will go back to is that we do talk about, and the focus that the panel has actually looked at is mission, service, stewardship. And it really is, and not even to be said in that way is the impact to employees and the taxpayers, and to be good stewards of taxpayer dollars. So a lot of the decisions that you are going to see, and if you look at these decisions in detail, because there are multiple issues that are raised, is that where the parties have actually been able to provide convincing and clear evidence of the impact to either the mission of the agency, being stewards of taxpayer dollars, meaning the cost associated with certain provisions and minimizing those costs, and the impact to the employees and the people that we serve, those are going to be the primary focus on how they make their determinations as to how to modify or how to or what provisions they are going to order to be adopted. So there are actually 7 particular issues in this case. I think the primary ones in this were, for me, the year, right? The appraisal year being changed. And then, of course, the other aspect was how often feedback is provided. And in this particular case, actually, I believe the panel actually went back to language and the CFR that talks about providing feedback at the beginning, mid, and end of the year of the appraisal process. So next case, also it's a DOD education activity. Union filed a request for assistance regarding a midterm negotiation impasse regarding the performance appraisal system. So there are 2 cases that came out relatively closely on these, and if you read them actually side by side or relative to each other, it gives you a more comprehensive picture of sort of the performance appraisal process that is identified by DP map. So the parties were able to reach agreement on several issues. And in this particular situation, so this one talked about the performance discussions. I think the interesting piece is that this decision is actually, I would not say in conflict, that all those people that are governed by this particular DOD instruction, there are schools or there are certain areas that actually have a different appraisal cycle than the one that was ordered or the one that was provided for in the provision in this particular situation. And that is because the scope of the bargaining in this particular situation was only for this region or for this particular area. Parties disagreed over first performance discussion, when the first performance discussion should occur. Union argued that it must occur within the first 30 days. The agency wanted for it to occur no later than 30 days after the next academic year. Of course, the panel determined that in order to comply with its own instructions, that the panel that the first performance discussion must be done within the first 30 days, and not really what the agency was proposing as to waiting into the beginning of a new school year. And the other issue in this particular situation was the final performance discussion will occur at the end of the school year. And the agency proposed that the third performance discussion occurred concurrently with the first performance discussion. So the agency was deferring the final performance discussion to occur at the same time as the first performance discussion of a new cycle. So they were basically conflating the two together at the same time. The authority said, so they went back with what the union had proposed, which was actually in alignment with 5 CFR. Department of State, Bureau of Consular Affairs, Passport Services. I think this is actually an interesting case to read. I don't know that there was anything significant to be talked about, except that in this particular situation, there was a modification of several of the management proposals to address, I want to say, timelines. That's probably the easiest way to say it. And there was actually, in this particular situation, there was a withdrawal by the union of a particular proposal while it was at impasse. And of course, the party was allowed to withdraw that. But this particular case really centers around employees accessing logs, disciplinary actions, registering data for unauthorized users. So as I said, while there were procedural issues, it's an interesting case to read. It's actually a very simpler case to read compared to some of the other decisions that have come out from the panel recently. Next case, Department of Defense Education Activity, 2018 FSIP 073. Union filed a request for assistance from the panel over negotiation disputes on a term agreement. Panel did assert jurisdiction over various issues. Parties resolved 30 issues at conference with a neutral, but could not resolve 10 outstanding issues. And they were about completing parent-teacher conferences on the work site, whether the school year may be extended as a result of unexpected closures, whether pay levels should be tied to certain levels of experience, regarding degrees, education, affirmative education requirements, employees being moved between locations. Panel adopted, actually, I would say of the 10 proposals, majority of them, the panel adopted management's position and did modify in several instances modification between the union, the labor, and the management position. U.S. Department of Army, Fort Rucker. This particular case, it was a CWS and what I said earlier, compressed work schedules case. The sole issue for the mediator in this particular panel-appointed mediator, or this was a MED-ARB, I should say, was whether the agency's determination to terminate the CWS program was supported by evidence that those schedules were causing an adverse agency impact. And in this particular case, the agency actually met the burden of presenting sufficient evidence to identify adverse impact for 3 out of the 6 locales that they were talking about. So in this particular situation, in those areas where the adverse impact was identified, the provisions were not imposed. So it was only those areas where there was no adverse impact that was clearly identifiable to the panel. And in that situation, they did impose, I'm sorry, so they did allow those work units to retain the compressed work schedule. So if they were able to provide adverse impact, they did not actually have to maintain those schedules. All right. PBGC, Pension Benefit Guarantee Association, Independent Union Pension Employees, issued. This decision was issued earlier this year. And while there were multiple issues that had been raised, there were certain issues that the panel did not assert jurisdiction. The panel did actually assert jurisdiction for two particular issues, and one was an issue on a suitability matter. The union claimed that management raised risk levels for some of its employees to get rid of long service employees. Agency, of course, denied the motive, and there was no evidence presented. So the panel ordered modified language, saying that if an employee was found unsuitable, the employer would have to follow applicable laws, rules, regulations. And then the second matter was about union ratification procedures, and it was just a discussion. The union had, I think, identified 45 days for ratifying the agreement, while management proposed 30 days. The panel went with the 30 days as a more reasonable proposal for union ratification of the contract. U.S. Housing and Urban Development. This was also issued in February of 2019. Let me make sure. So this particular case is actually entering. I'm not going to go through this. It's very lengthy. So I'm not going to go through everything details, but I'm going to identify those issues that are in this particular case so that if you have those issues that you're dealing with, this would be very interesting. So this talked about even the purpose, the location of negotiations, matters related to negotiations, logistics process, official time, proposals, mediation, impasse procedures, ratification. So in this particular case, I think the one actually thing, when we talk about location of negotiations, the union's position in that particular issue was that management's time schedule and limited budget for union officials to participate was meant to bankrupt the union. Management complained that the current contract that was negotiated between 2010 and 2015 cost the agency for travel and per diem close to $260,000. Now, the reason I mentioned this actual specific issue is because in this particular situation, and in a lot of the other cases that you see, where management actually can identify a dollar figure and identify how much waste or unnecessary cost, right, went into certain aspects of negotiations, and the panel will find that, of course, a more expedient, more streamlined, and less costly process is going to be the better process. So this is actually a really good case if you are actually going to be looking at ground rules negotiations anytime soon. There's actually quite a few cases that have come out recently on ground rules and negotiations that I think would be very helpful for the parties to review. Next case we have is Social Security Administration, AFGE 33, Local 3342. This was actually quite interesting because in my experience, I've had actually in the past a panel order offices to be created where we didn't feel there was a need for one, or actually, require some significant structural changes to a space move that had costs associated with it. So in this particular case, it's actually pretty interesting. The issue that the panel had before it was about creating windows. So in this particular situation, the union wanted 2 windows to a particular floor plan to get natural light for the bargaining unit employees. And the agency, of course, said that it was cost prohibitive for 2 windows for that particular space. And the agency proposed putting in LED lighting. The panel actually adopted that and said that, for the costs associated with it, LED lights would actually serve the purpose, the needs of the employees, as well as mitigate the additional cost for creating the window or for creating 2 new windows. Department of Defense, again, this is a ground rules case, and so quite a lengthy case. There are 12 ground rule issues in dispute. So if you're actually going to be negotiating ground rules or in ground rules negotiations and possibly go on the panel, this would be a good case to review, because same issues: size of negotiation teams, travel, duty, authorization, travel expenses. In this particular case, actually, management capped expenses for travel and per diem for a specific amount for negotiations. And the union disagreed, of course, with the cap. Panel adopted management's proposal, stating that the cap is reasonable and consistent with management's fiscal responsibilities. So, without going into all the issues, again, I'm going to go back to evidence. If you have clear and direct evidence that will support your argument, as well as any costs that you can support, if there's costs to, union paid or taxpayer funded union time, it is to your benefit to actually have those readily available or make those arguments to the panel when you are providing your written submissions. In this particular case, there's 12 provisions, and I think that's actually a good case to actually read if you are going to be doing ground rules and negotiations. So the next case is Department of Treasury, Bureau of Engraving and Printing, Washington Plate Printers. In this particular case, it was the use of an automated time system. In 2004, the agency started using WebTA, which is an automated system, but it was only requiring the non-bargaining unit employees to actually utilize that. Now, of course, 14 years later, they want to actually have all employees utilize the system. Unions objected to the change, arguing that employees don't have the time in their schedules to do the timekeeping. However, supervisors were actually previously putting in the time for all of their employees. Panel actually did not find that to be convincing, and they determined that the agency's was the best proposal, and adopted that. So, U.S. Department of Air Force, Shepherd Air Force Base, AFGE Local 779. This was based on a dress code. Union argued, okay, so the management sent the union a proposed dress code proposal based on dress and grooming standards. Union submitted a proposal to allow the employees to wear shorts because it says it allows for them to work longer hours in the heat of the day to accomplish the agency mission. There was a duty to bargain determination that was raised in this case. And so, of course, the panel had to go back and take a look at the requirements under Carswell and to see if it has jurisdiction. So in this particular case, neither party presented case law to demonstrate the negotiability of the issue. Therefore, the negotiability of the proposal needs to be addressed by the authority before the panel can resolve the impasse. So in the absence of case law that was provided, the panel did defer to the authority. Department of Health, Human Services, and NTU. So in this particular case, it was ground rules proposals as well. Actually, this one concerning it wasn't ground rules proposals. It was actually proposals for the successor collective bargaining agreement. The issues at impasse were official time, telework, holiday time, and overtime, and union office space on bulletins and billboards. And again, it goes down to what is reasonable, necessary, and in the public interest was really the direction that the panel took, and analyzing and making their assessments for what provisions would be imposed. So it's a lot of material, and I know that I actually quite a little bit longer than 1 hour. So I want to thank you for your time and enjoy the rest of your day.
Thank you, Amanda. And thanks for sharing your expertise during today's training on the Federal Service Impasses Panel. Your presentation has provided an outstanding and informational overview of the panel and its decisions. This ultimately supports the 3 PMA pillars of mission, service, and stewardship by providing some tools to help promote mission delivery. Thank you, and we look forward to having you at the next Employee and Labor Relations training. And finally, please remember to fill out the online evaluation form, courtesy of SurveyMonkey.com. Your feedback helps us to plan future trainings, and we appreciate you taking the time to complete this survey. Have a great day.